Well, good afternoon. I hope you can see and hear us okay. We might just, there's a couple of people that have joined the webinar so far. We might just give it another minute or so, just in case anybody else is still trying to log in. The weather is nice where you are. We're in Hamilton. It's a rather grey day. I think we've definitely seen the end of summer, whatever summer there was. It's taken a turn towards autumn for us. Okay, well, look, we are at 1:01 p.m. now, so let's kick this off. So thank you for joining us today. I'm Andy Hart from FEBC, and we're really pleased to be bringing you this webinar today in association with Public Trust. We've been working with the team at Public Trust for a while now, and I really appreciate their expertise as New Zealand's largest and most experienced provider of wills and estate administration services. This webinar is part of a campaign that we're running that allows you to get a discount on making a will with Public Trust. If you haven't registered for the discount offer yet, there is still time to do that. Go to our website, febc.nz, or put your email address in the chat window, and we'll be able to get back to you and help you through that process. The chat window is where you can also ask questions during today's webinar. If you don't have it open yet, at the top of your screen, you should see various options, a menu with various options. One of them says chat, and if you click on that, a window will open up. Generally, it's on the right-hand side of your screen. And at the bottom, there is a panel where you can type in your questions and comments. So please do ask questions and make comments as the webinar goes, and we'll be monitoring that and provide answers as we go. A little bit about FEBC. So FEBC, for those of you that don't know, stands for Far East Broadcasting Company, and we're an international association of Christian radio stations and media outlets that broadcast God's love literally to millions of people around the world. FEBC operates throughout Asia and the Middle East, Africa, into Russia and parts of Eastern Europe as well. And our broadcasters are speaking to people who need to hear the message of Jesus Christ in closed countries like North Korea, in places that are ravaged by earthquakes and floods and other natural disasters, and in war zones like in Ukraine. If you do feel led to leave a gift in your will to a charity, please do prayerfully consider FEBC. It's a very effective ministry and will ensure that your legacy has a global impact for generations to come. But you don't have to support FEBC to be on this webinar, nor do you have to support FEBC to get the discount to make your will through Public Trust. We believe it's a solid biblical principle to pass on a legacy to the next generation. So we'd love to help all New Zealanders to be prepared by having an up-to-date will in place. And that's a goal that we share with Public Trust. And I'm now pleased to hand over to the Public Trust team of Natasha Taylor, who we've got, who's a Senior Trustee, and Chris Davis, a Digital Trustee, who will tell you a little bit more about Public Trust and demonstrate the online will creation platform. Over to you, Natasha.
Thanks, Andy. So I am going to share my screen with you. So as Andy says, I am a senior trustee here in Christchurch. I have been with Public Trust for 2 years now, and my passion is people, and I really do enjoy sitting down and having a really good conversation with people around their wishes if they didn't have a voice at the time. So today, what I'm going to do is I'm going to spend a couple of minutes talking about Public Trust, and then I will pass you on over to Chris. And Chris is a digital trustee. So Chris supports both our customers and our teams here at Public Trust with the digital self-service side of things. This supports you making a will and drafting up enduring power of attorneys. He has been working with Public Trust now for 4.5 years, and he is an expert in his field and relied on by many. So, who is Public Trust? So many of you would recognize the household name, but did you know that we are actually 150 years old this year? So for us, that means that we've had 150 years of having conversations with clients, beneficiaries, charities, etc., making their needs met for when they most need a voice or an arm of support. Public trust, however, not only supports with wills and enduring power of attorneys, we have another arm that deals with conservatorship, so helping vulnerable New Zealanders who can't help themselves. We also have a huge charitable trust where we manage the funds of other charitable trusts. So we're actually very big. Today, however, we are going to talk about how easy it is and accessible it is, and how public trust has made this so that you can actually get your wishes all put in place for when you most need it. And we do this by supporting you with an online digital platform, which Chris is going to talk about in a moment. And this is to support you putting wills and enduring power of attorneys in place. So just a wee bit more information of exactly what we do here in our centres. So wills, so we've talked about that we do support you with wills, and this is important because when you do administer a will, you're not here, so you won't have a voice. So it is important that through the online platform or in centre here that we take the time and you take the time to sit down and put in exactly what it is that you would like to put in your will when you're not here. Trust. So this is a legal arrangement. So, for example, if you've got a property that you would like to protect, this can be placed into your trust. And again, a conversation that we have around, the why. Why is it that it is important to you to do this, and we can support you with that. Enduring power of attorneys, this I explain it as the living document, okay? So you're still alive, but you may not necessarily have a voice to speak for yourself, or you may not be able to do what you feel you need to do, and you need someone who you can trust to come in and be that person. So we have lots of conversations with our clients, and they'll talk about how they would like family to support them. We talk about when they would like that support, so whether they're mentally incapable or whether they do have that capacity. So it's entirely up to them when they decide to do that. And by having a really good, thorough conversation, they'll understand exactly why it is important to them and to protect their assets when, as I said, that they don't have the voice. Estate administration. Estate administration, again, look, this is where the will comes in. So when you've written down those wishes, you will talk then around who you would like to leave, your legacy, your assets to. And we talk about how long it takes you actually to build up those assets, and thinking about what it is important to you and who you want to leave those to. So to kind of get that all down in writing, so when you don't have a voice because you won't be here, we can support with that and supporting your beneficiaries. And triple PR and private management services. So this is in support of either a court-appointed triple PR. So if you didn't have an enduring power of attorney in place, the court might say, hey, actually, public trust, I support you with your application to support this client. So we will pick up those clients there under a triple PR. Under a private manager services, we call this a PA. So what this would mean is that if you have allocated public trust to be enduring power of attorney, we again will come in and will support you around your finances and your property, and this includes your home, your bank accounts. We support with your transition into a rest home, and I must admit this is actually my favorite part, because I do love going and visiting all my clients in the rest home or in their homes and wherever they be. So so there's a lot that we do, and as I said, look, being my passion, there is a lot of opportunity for us to come and have a really nice discussion around what it is you want and how we can support there. So before I pass to Chris, we'll just give you some wee figures here. So each year Public Trust helps nearly 1,400 customers continue their legacy by managing their estate. We help around 7,600 people write a will and protect their legacy. And now we've made it, as I said, even more easier because we've got that online platform. So in the comfort of your own home, you can sit down, you can have a conversation with your family, and you can really have a good view on exactly what it is that you need. We help over 2,000 people write an enduring power of attorney and make sure that someone can make decisions if they can't. And we talked about that being the living document. And we've also paid out over 600 million in distributions and bequests to over 7,600 beneficiaries. So massive, lots, but we couldn't do this without the help and the support of New Zealanders. And so on behalf of Public Trust, thank you, and I will pass you over to Chris now. Thanks.
Excellent. Thank you very much, Natasha. So I am going to run through some of the online system, and we're going to have a wee look in regards to what we can offer and how to do it. So one of the first things I wanted to just run you through is our pricing screen. So we can see here on our main website at publictrust.co.nz, we do have our pricing options here for the will, starting at $79, going through to $199. Now, the handy thing is that if you wanted to get a quick idea around what will you should be going with, you can go to the Making a Will option and click the Find the Right Will option here. And then this will ask you a series of questions, and it will then confirm which level of will you should be on and what kind of price point you're likely to be looking at. Just quickly as well, I would also like to just show you on the screen is that we do have a live chat function as well for if you do decide to do your will online. We typically respond under 3 minutes currently, and that is available on the main website for planning and creating the will itself. We do, of course, also have the 0800 number you can give us a ring on as well, which we're available from 9 till 7 p.m. Monday to Friday, and weekends we're available 10 till 4. Now, there's not a huge wait time with that as well, because we tend to answer 90% of our calls within 20 seconds on that line. You can find those details right at the bottom on this website. So if you were looking to go ahead and sign up to our website, I'm going to show you through quickly how you can create an easy will. So,
Chris,
yes.
Can you hear me? This is Andy. I just
Hi,
noted
Andy.
that there's a message in the chat. Somebody saying they can't see your presentation.
Oh, they can't see it. Okay, that's all
I'm
right.
not sure.
Is anyone else able to see it okay?
So it's coming up okay for me.
For you? Okay. So
yeah, it's working for me as well.
It's working for you as well. Maybe I could stop sharing and I'll share again. We'll just see if that gets it going.
Thank you. We'll try that.
Okay. Hopefully that's come up now. Is that working now?
Yep, for me, I can see.
Yeah, it's working okay for me as well.
Okay.
I might have to take it offline if Graham still can't see it, but he can see it now. Perfect.
Oh, he can see it now.
Thank you very much,
Excellent.
Chris. Appreciate that.
Easy peasy. Glad to hear. Cool. Okay, so I'm going to go show you through the process of signing up to our online service and creating a simple will. Now, the website address for this would be publictrustonline.co.nz, or you can go from our main website, which is just publictrust.co.nz. So when you get into the online system, the first thing you'll see here is the sign up screen. Now, just keeping in mind that the system that I am using is a training environment system, just to be sure that we aren't showing any details of our existing customers. So we'll click the sign up option here, and first of all, we're going to start off by entering our full legal name, and this is as it appears in your ID. So keeping in mind this is a legal document, so you need to be sure that the information is correct that's being entered here. Okay, and then it will ask you for your date of birth, so I'm going to pop that in. Lovely. My email address. And then a password. Okay, and I'll ask you to click here to accept the terms of engagement. So just make sure if you've got a couple of minutes to have a read of those, and then we sign up. Oh, and I didn't put enough characters in my password, so let's just change that one. Okay, so that should now load, and it'll say you've completed your registration, your public trust account is now active. So now we can get started on the will or EPA or statement of wishes, depending on what we'd like to run on. So this is the dashboard. Now the dashboard is otherwise known as the menu screen. So at all times, there should be the dashboard button that appears at the top left. So if you do get lost somewhere, you can just click that button and it will take you straight into this screen here. Now, what we want to work on today is the will screen. So we're going to click on Start under the will. Now, once you get into the will option, or once you first click on it, you will receive a prompt that comes up on the left, and this is going to give you directions around what to do. So starting out, you need to complete the interview tiles. You can then pay and download. If you'd like to, you can consult with an expert review, which we'll talk about shortly. You can also mirror your will, which also has its own discount on top of that as well. And then you need to sign the will and upload it. We'll talk a little bit more about some of those steps soon. So to get started with your will, this is now the will planning screen. Okay, so as I mentioned before, if you get lost, you've got the dashboard at the top left. Along the top bar, you've got some additional options here, such as the guide that will reopen the guide for you. You've got the preview option as well. So as you go through and draft the document, you can click preview, and this will give you a live feed of the information that you're entering as you're entering it. So that way you can double check it to make sure you're happy with it. We also have the pay and download button here, FAQs, and also the mirror function as well. So what a mirror function is basically it will take the information that you've entered on the first will that you've created, and it will duplicate that information and do a mirror image into, say, your spouse or partner's will. It saves quite a lot of time, providing you've more or less fully prepared the first will, but there is also room for you to make adjustments on the second document as you need after the payment's gone through. So let's go through and get started. So first of all, we want to look at the you option. So these are what we refer to as our tiles. So we want to go into each of these tiles and provide answers. So the first option is you. Again, you've got your guide on the left that comes up to give you some instructions around what needs to be done. Okay, so the first question it's going to ask is what are the main reasons for updating the will? Now, I'm going to suggest that somebody recently has passed away and it's made me think about that. It'll ask me my gender, which is male. It'll ask me my phone number. Pretty simple stuff. It'll ask me what my occupation is. So I'm going to put that I am a digital trustee. It'll now ask me where I live. Now, I myself am based in South Canterbury, and I'm going to put down that I am at 9 Elizabeth Street, which is where the office I'm based at is. Okay. So it will then ask you to double check the information is correct. And now it's going to ask you if you own a home. So in this case, let's just pretend this is my house rather than my office. So I'm going to select yes, I do own a home, and that it will now ask you to register the home that you own or note the property that you own. So for me, I only own the one house. So I'm going to use the street address from above, and it will pre-fill this out. It'll ask me how I own the home. So I'm going to select that I own it jointly with my partner and whether it's owned by a family trust. In this instance, that would be no for me. We click save. It will now ask me if I'm a business owner. So I'm going to select no on this option. And it will ask me if I have any overseas assets. Now, as an example, I'm going to select yes that I do, because I do have some assets that are held over in the UK. Now, if you were to select no, it wouldn't give you another prompt, but because I do, it's now asking me if I want this will to only be related to my New Zealand assets. So in this instance, I do want this will to only be limited to the assets here because I have a separate will in the United Kingdom. And we click save and done. So now that that's done, what we can see here is that that the U box is now 10 red. So that gives me an indication that that box is now complete and I can move to the next one. So the next one we're going to look at is the relationship field. So this is going to confirm some details around my partner. So in this instance, I'm going to list here that I'm married. Now, depending on what option you select here, it is going to give you different options in regards to the questions below. So the first thing it's going to ask me here is it's going to ask me to identify my partner. Now, there's nothing currently listed, so I'm going to add my partner in. So I'm going to put my partner down here. Okay, my partner's in Timaru. She is a accountant, and her details here. Okay, and then I can click save. So my partner has now been added in here, and because she's been added in the once, this means that her details are now going to be saved in the system. So in future instances where she needs to be selected, it will be a drop-down list. It's now asking if I have a blended family. So this is asking if I have children from previous relationships, which me or my partner don't. So we'll click no. And it's now asking if I have a contracting out agreement. So that's like a prenup. So in this instance, I'm going to just say yes, that I do. And it's now asking me around the date of that prenup. So I'm going to put the 1st of the 2nd, 2020. Okay, and we'll save that. Okay, so as we can see now, the relationship field has been completed, and now we're just moving on to the children's field. So we can edit that one. Now, me and my partner have one child. So we're going to select yes and continue. Okay, so my child's name is going to be Sally Ann Davies, female. She is my legal child. And is this child a minor? So we're going to select yes. And she was born on the 1st of December 2020. Okay, now because I've selected yes that she's a minor, what will now happen is it will come up asking if there's another legal guardian of Sally. So I'm going to select yes. And because I had Sally with Tanya, we'll select Tanya here and we can save. So this is going to link everything together. So when we now answer the next set of questions, which is the guardianship option, it's now going to all sort of come together. So there are some other additional options that we would then select. So I'm not going to run through those for time, but we've got family trusts here if you were to have a family trust, and we've got wishes. That's where you can leave notes around what your funeral wishes are, whether you would like to be buried or cremated and things like that. Okay. The next option that we'll run through will be the representatives option. So the representative option here is going to be asking questions around who you would like your executor to be of the estate. Now, by default, to make sure that your will is valid, it will default to public trust. Now, this can be changed if you would prefer that public trust wasn't the executor of your estate, but we would just note that it's very important that the person you choose to be your executor is trustworthy, and that they would be able to manage the process of your estate. So public trust is a good option for if you were to have, say, young children, or you had a situation where there wasn't very many people that you would want to burden that responsibility with. Okay. So moving along now, so administration service isn't required because public trust is the executor. You can appoint some special trust advisors. Now the format of these boxes is basically the same as some of the others, so we're going to skip these. A special trust advisor is a person who is appointed to basically be like a point of call to the executor. So they can assist and are also provided information regarding the estate. So we'll move to child guardians now because we want to get the will finished off. So The child guardians section is going to appoint a testamentary guardian in the will to look after or be aware of the welfare and finances of that child. Okay, there is some more information on this guide, which will help sort of give you a bit of an idea around what this is and how this works. So we're going to add a child guardian in. So we're going to select at this stage all of my children, because I don't know if I'm going to have any more children yet. So we'll select that. So it's now asking again if there's another legal guardian of your children. So yes, there is. And my other legal guardian is Tanya. Okay, so it's now asking, would you like to appoint a testamentary guardian to work with Tanya? So we can either appoint someone to work with Tanya, or we can appoint somebody so that it's only if something happened to Tanya would that person be in that position. So I'm going to select a backup. Okay, now it's coming up with a prompt here saying that you've appointed a sole guardian. Because Tanya is already the other legal guardian of your children, your will does not need to add a clause for Tanya to be listed. Okay, so that's just a wee note so you don't get a fright when you look at the preview. So we're going to appoint a backup, and in this instance I'm going to pick my mum to be the person. Okay, and so my relationship to her is she is my mother, female, Timaru. Oh, wrong way around, retired, Timaru, and we'll save. Okay, and we're going to save that. And then we can save it again because that box is now gone and done and turned red. So just coming back to that preview button again, I mentioned before about this being a live feed. So if you now click on the preview button, we can see some of the things that we've already entered in. So we can see here that the scope of the will, so this is the question that's asked around whether my estate is just in New Zealand. There's a clause relating to that. There's a clause regarding to the executorship, and now there's also a clause there for guardianship. So it's notes here that if my wife Tanya dies before me, I appoint my mother Carleen Betty Davies to be the guardian of my children. Okay, so moving along from there, now we need to work out what's going to happen to the estate. How is this going to work? Now, for my situation, I want to make it pretty easy. So basically, I want everything to go to my partner first, and then I want it to go to my children as a backup. Okay. Now, one thing I should consider though also is what about their children? Now, I realize that my daughter now is probably a little bit too young to have children of her own, but if, for instance, I hadn't updated my will for some time, would I want her children to potentially benefit? So what I'm going to do is, that is something that I want to do, so I'm going to select alter my spouse with current children and their children as backups, and then we'll click continue. So now the system has been added in, has added in a prompt to say that everything's going to Tanya first, then it's to my children, and then the grandchildren. Now, because my daughter is so young, I'm thinking, should there potentially be another backup? So in this instance, if we were to all pass away together, currently there's nowhere else for the estate to go to. So in this instance, I want to add a backup to go to my mum. So I'm going to add person, and then we can add solely, and we can see here that the people we've previously entered are now in here. So we can go my mum, and we can go provide for future beneficiaries. We'll select no, because that doesn't apply. So the future beneficiaries would only apply if, for instance, it was your children. So you could have name your children and then apply to have additional children in there as well. So now that's all been done, we can click save and done, and the estate options now complete. So the last thing I did just want to show you is around the specific gifts. So the estates section covers off basically everything that's not already specifically gifted, and obviously your debts and things like that after payment. So that's pretty much the bulk load. But in my situation, I do want to give a gift to FEBC. So I would like to give them a cash sum of $5,000. So here you can select yes under gifts and continue. Okay, we can go add new gift, cash sum, and I want to add $5,000. Well, actually, let's make it 50,000. There we go. And we'll go charity. Now, in this instance, there is this is a training environment, so I believe it may not have been updated for a while, but I can confirm that the FEBC is listed in our other system. So I'm just going to add my own because they're not in this list, and we're going to put in FEBC New Zealand. Okay, and we'll save, and then we can save again, and done, and save and done again. There we go. So that is more or less how to actually create the will. So this is actually going to give me now my will that I need. So the next steps from here is to go through the payment option. So to go through the payment option, you simply click on pay and download and click there to complete payment. Now, if for instance I wanted to purchase the mirror, I could tick this option. And then this will then create the mirror for my partner, as I mentioned below. So I'm going to click on proceed on this. And it's also coming up saying that because I'm creating a mirror and I have overseas assets, the fee for this will is going to be $318. I'll click continue. I can then select here my partner Tanya and continue. It's now going to prepare my order. Now, if, for instance, the offer I have been given includes a coupon code, that's where I'd enter that here. Otherwise, I have read and accepted the terms of payment. I've double checked that what I'm paying for is what I want. I click continue, and then we enter in the card details. Now, this is a dummy card, obviously, so I'm hoping it's still going to work. Oh, excuse me, sorry. 2124. Let's try that. Payment method. Okay, so now that I've clicked that, the payment is now processing. Congratulations, there we go, the payment has now gone through. And we can now go back to continue editing, and now we have a paid for will. Now, once this reloads, we now also see that we've got my name and my partner's name here, so we can flick between the two wills, and basically everything I've inputted in this side of it will now be in my partner's name as well from my partner's perspective. So as an example, we can go to manage her will, and then we can select that preview option, and we can see here that the same things are still in here. So we can see we've got that gift of FEBC, we've got everything is going to my partner, and then it's going to my children, which is highlighted here, and then to my partner's mother. Okay, now in regards to a case of that I have purchased, I'm unsure and I want someone to double check it, that's where you can engage an expert, which is this button down here, or under the need help option. So the expert review is a good option for somebody in the digital team and our legal team to cast their eye over the document. Once they've cast their eye over the document, they'll then provide feedback by email for suggested improvements. All is also not lost if, for instance, you go into the online system, you paid for it, but you would then prefer to come into the centre. We can also switch you over and refund the online fees if you'd prefer to come in and see someone in the office there. Next steps from here, though, if you're happy with everything, you can just select download will. Okay, now because I'm on Tanya's account, it's blocked me because I haven't entered her phone number. Okay, so it won't let you download if there's anything vital missing. So because I haven't updated Tanya's number, I'm going to flick to me and we'll download mine. Okay, so we download our will here. So it does note that we are missing some information. So we're missing information around the family trust, wishes, special trust advisor, those things. I'm quite happy in regards to the options that I'm missing here because I've double checked them. So we'll download. The will then download as a PDF onto your computer. So next steps from here is that basically you would print the will out single-sided in colour, and you would sign it with 2 impartial witnesses. Now, your impartial witnesses can't be family members, and they can't be anyone receiving anything in the actual will itself. Now, if you would prefer for public trust to witness your will, we can have that arranged. There is a surcharge of $59 per will for that to happen, and you would need to get in touch with us to make that appointment. But otherwise, that is it. That is how you create a will. So if anyone has any questions, fire away.
Thank you, Chris. While people are typing their questions in, if they have any, into the chat function, we do have a few questions that were sent through earlier that I might read out for Natasha or yourself to answer. So let's start with... There was a question that came through in the chat. What constitutes a minor? Up until what age is a minor?
I can answer that. So up to the years of 18, it's a minor. You will see in the will that you have, when you're talking about children and leaving gifting to children, you don't necessarily need to give them the funds at 18. You can decide when you want to give them the funds. So 21, 25. But 18 is the minor, is up to the 18 years of age. You become an adult.
Awesome, thank you. And a common question that does get asked, Natasha, is, do I have enough assets to make a will?
Yep. So firstly, anyone can make a will because we don't know what the picture is going to look like when you do finally pass away. However, when you're looking at administrating a will, anything up to 15,000, you do not need to either get probate or an election to administer. Anyone, your family can support on anything up to 15,000. Anything above 15,000, you will need to apply for probate to administer. So that will mean that you will need the legal documents to be able to support or to get support with administrating your will. Now, we need to think about, for example, KiwiSaver. KiwiSaver being in your own name, a lot of people do have KiwiSaver. So if you are thinking about writing a will, just remember to actually think about KiwiSaver, because if it is over 15,000, you absolutely will need to apply for probate on that one.
Thank you. We have had another question come through
Mhm.
from Graham. What sort of fees do public trusts charge to be an executor or to give legal or digital advice? I think there's 3 questions there. So we might start with what our fees are to be an executor, and maybe you can also touch on the Public Trust Act and what's in there.
Okay, so it depends. I mean, I will cover around the fees. So it depends on what we're doing. There is a great link on our website in regards to our fees of administrating. So we do have some set fees that we need to consider. There is an administration fee. This is an estate administration fee, and we also have finalisation fees. But there's also other set fees such as probate. If we are conveyancing a property, if the property is for sale, we have set fees around the sale of the property. And we also have time and attendance fees. So on our website, as I said, if you click on fees, it will outline exactly what our set fees are, and it will outline our time and attendance as well. So it very much depends on the estate and what we do need to support with.
I've just shared the link, so people in
Thank
the
you.
chat function, so people can click on that and follow the signs, as they say.
Nice. Yeah.
Another question has come through from Don. I have an existing will dated May 2007. Do I start the process as you've showed us, or can I update this one, which presumably is already on your records? If I'm able to update it, how do I go about this?
I can answer that if you like. So, so the online system for us is a couple of years old now, but unfortunately, any wills that were created prior to around 2019 can't be placed onto the new system. So it would be a case of that you would basically sign up, like I showed you on the screen there, and basically redo your will. If you would like a copy of your older will, if you don't have a copy, you can give us a call and we can arrange for that to come to you. The other option is, of course, you can come into the office and the office will be able to do the will for you too.
Now, this is on the assumption that the will is with public trust. If the
Of
will
course.
isn't with public trust, what would the process be then?
It would be the same. So it would go
Yep.
through the sign up process.
Okay, thank you.
And if you, sorry, can I just add to that, Chris? So if you do have a will with public trust that is dated 2007 and there are no changes that need to be made on that, you can actually retain that will, but just give us a ring and let us know that it is still your current will, and we will just note it on the system, because that is important to us too.
Now, you did mention earlier, Natasha, in your presentation about the executor, and so did Chris. How important is it to appoint an appropriate executor?
I'm happy to answer that. So bearing in mind that this is your legacy, so this is everything that you have worked for the whole of your life, okay? And remembering that these wishes, it will be important to appoint someone who you can trust, who can make this a very simple process for your family. Because remember, we're dealing with families that are grieving. You'll have just passed away, so they will need the support of a very faithful and strong executor, who will be able to take on all the duties of applying for probate, of calling in the assets, and distributing your estate. So you'll need to choose someone who, as I said, you can trust with your estate, who you know would be on the same page as you in regards to the support that is needed for your family. And a benefit of, for example, public trust as opposed to an individual is, as I explained earlier on, we're 150 years old. You know, you're not limited to one person. So we could support either doing the executiveship, where we do everything, or we do have a team that is behind the scenes. And what they can do is that if you did choose a family member as the executor, they'll come on board with you, and they can actually do all the legalities, probate, and so on. So there's lots of different options. But back to your question, absolutely someone that you feel that you can trust and who will be able to support you from beginning to end with your estate.
So to summarize, public trust could be an executor, or if a family member is being appointed or someone else, they can run it themselves, or they can engage public trust to help them run it if alongside them.
Absolutely. Yep.
Now, a question that came through earlier was quite an interesting one. If a couple name each other executors of their wills, what happens in the event if they both pass away together? And what provision should be considered for this scenario?
Do you want to answer that one, Chris, or do you want me to?
I'll let you answer that one, because
Nice.
you're more in the administration side of it, where I'm more in the will drafting.
Nice. So look, as I said earlier on, this is where, when we're having an initial conversation with you, we're going to talk about the options. Because look, you know, there could be a likelihood that both of you did pass away at the same time. So we would guide you around, you know, actually, if that was the case, who else could you trust to take that place? And going back to what you said, Amar, it could be another person, or it could be the likes of public trust to be able to support. So, for example, I'm married, and if my husband, if I died before him, I'd love to appoint him as my executor. However, if I felt, hey, look, that if he died before me or we died together, I would need someone else to be put in that place. So I know that to make sure that I didn't need to have to change my will again down the track, I would place someone else, and the likelihood would be public trust. And therefore, I know, as I said, that they're not going to go. I'm not going to have to worry about if they're not there. So,
Oh, so like having a backstop.
yeah, it's absolutely like having a backstop. And another thing that sorry, just to go on a bit, but another thing that Chris mentioned, it was the advisory trustee. So if you did want to choose public trust as your executor, you can actually, we are going to communicate with your family, but if there's something particular that you want us to advise a certain person or people in your family, you can allocate them as the advisory trustee, and we would be consulting with them on those matters.
Another question's come through, which is if a previous will was with somebody else, I'm presuming a lawyer or another organization, what should be done to cancel that will if you're creating a new one?
So
Nice.
the advice that we usually provide is really to make sure that your new will has been signed before you cancel your old will or communicate with them for the cancellation. Now, our wills have a clause built into them which state that basically once this new will has been signed, that it will automatically revoke previous wills. But to avoid confusion when you've passed away, we do usually recommend after you've signed the new one to contact them to advise them that you've signed a new will elsewhere. They may require some additional information from you, but that's just depending on what their processes are.
Okay. And where should one store their will?
So the recommendation for us would normally be to actually store it with the public trust if possible, especially if public trust is appointed the executor. It's really important to remember that with a will, it's the original will that needs to be sent to the courts after you die to obtain probate. Now, if the original will is lost, it's likely to incur some additional costings to your estate, which wasn't really necessary, and it will cause some delays. So there is no charge to store, or no additional charge, sorry, to store the will with public trust. So the idea is really to sign it, have it signed, drop it in when you're free next, and we'll look after it for you. It's quite interesting, just slightly to go off topic. The branch that I work in is the Timaru branch. There are some wills that are very old that haven't been actioned because we weren't aware of the person passing away, and they are handwritten and held together by ribbon. So give you an indication of the age of those. So we don't go ahead and biff things out. Certainly, until we know, they stay there.
Talking about the administration process, one word I get stuck on is probate. What does probate mean, and how long does it usually take?
Great. So probate is really the permission. So you're asking permission of the courts to administer the will legally. So what we need to do is when someone passes that they do have a will with public trust, we obtain the death certificate. We get a good understanding around the cause of death. If there is any capacity issues, we just need to clarify exactly whether the person had capacity when they were writing the will, and then we would apply to the court and say, hey, look, public trust has been the executor for Mrs. Brand's will, and we would now like to gain that permission that you're happy that we can go ahead and administer it. through the courts. Current time frame, you're looking at around the 14 to 15 week mark from the time that we send it off to the courts. So it does take about 3 months, and so it is a process that, because we are reliant on external bodies, that can take time.
Okay. Thank you. I do have 2 more questions that were sent in beforehand, and so that might give people some more time to enter any more that they have in the chat function. The first one of those questions is about a mirror will. So if I were to create a mirror will online with public trust, what does that mean, and can I have any differences in that will?
Yeah, sure. So the mirror will function online really is to create a will that mirrors the first one. So like I showed before in the example, so some of this may have already been answered. It will basically take the first will that you've done, flip it over into the partner's will.
Okay.
Now, in regards to adjustments, the mirror happens once and once only. So basically, once that has been mirrored, you can go between the two and adjust and change what you need to. We do just want you to make sure that you are double checking, I guess, against each will, because if, for instance, you've got things going to different parties and different wills, that could potentially pose a problem after you've passed away. If it is a case that you want, quite a significant amount of things going to different parties, we would usually recommend an expert review in that instance.
Okay. So when in doubt, get an expert review.
Pretty much, yeah.
And the last I have on my list here, oh no, I think we've answered everything that has come through.
Right.
Nice.
If there are no other questions, I might throw back to Andy to close the session.
Yep, that's excellent. Thank you very much, Amar. Thank you, Chris. Thank you, Natasha. And thank you to all of our attendees who's participated and made it a really worthwhile session today. Really appreciated the questions. As I said before, if you haven't taken up the offer of the discount on a will yet, you can still do that. Visit febc.nz. So it's not .co.nz, it's just febc.nz. And we would be happy to help you out. That's all for today. Again, thank you to the Public Trust team. Been great dealing with you. And thank you again to everyone that's attended. Oh, I see somebody's actually typing something here. Oh, it's Chris.
That is actually just me. I was actually just going to sneakily pop something in the chat and just suggest, if you do have any other questions that you have, I am around until 5 p.m. and will be on the live chat as well. So if you did want to go to our Public Trust website, type in a question you have, just put attention Chris and I'll happily answer it for you.
Thank you,
Perfect.
Chris. And
Cool.
Andy, my understanding is you will circulate the presentation for viewing again.
So this is the recording of today's
Yes.
webinar? Yeah, definitely. Thank you. Once we get it from you, and that normally takes a couple of days to come through, yeah?
Yes.
Okay. All right.
All right.
Thank you again.
You.
Yeah.
Thank you.
Ka kite anō.
Have a good day.
Bye-bye.
Bye-bye.